Welcome back to National IAS Academy. My name is Raj Shekhar. Dear friends, welcome back to our new initiative, that is Focus 300 initiative, under which we shall be covering 300 most important topics from UPSC Civil Services preliminary examination perspective. And in this journey, we have already covered nearly 270 topics. We are left with 30 more topics. And in today's class, I shall be covering the next 10 most important topics from UPSC preliminary examination perspective. So without waiting much, let us begin straight away today's class. The first topic is related to right to access justice. Please note that right to access justice has been indirectly covered under Article 21 of the Indian Constitution, which is protection of life and personal liberty. The context is recently, that is in the month of September 2022, Supreme Court has ruled that live streaming of all its proceedings, mainly constitution bench related matters or proceedings, shall be live streamed through a special software, and this forms the part of the right to access justice, which has been covered under Article 21 of the Indian Constitution. All right. So the Supreme Court recently made the decision to stream live its proceedings in a significant constitution bench matters. This was started from September 2022. And the Supreme Court believes that broadcasting of judicial sessions will have positive systemic improvements. Also, previously in the year 2018, in Swapnil Tripathi versus Supreme Court of India case, that is the 2018 case, the Supreme Court had decided in favor of live streaming of proceedings at the top court. And following this, the Gujarat state had become the first state in the entire country to live stream its high court proceedings, and it was followed by the Karnataka state government. Like that, we now have Jharkhand, Karnataka, Madhya Pradesh, Orissa, and Patna high courts currently live streaming their proceedings. All right, so let us briefly revise. The context is simple. The topic is related to right to access justice, which has been covered under Article 21 of the Indian Constitution, which is once again related to protection of life and personal liberty. And Supreme Court in the month of September 2022 said that the proceedings of important matters pertaining to Constitution bench jurisdiction shall be live streamed. So this forms a part of right to access justice, which is a part of Article 21 of the Indian Constitution. That's it. Next is right to bodily autonomy and integrity. The context is pretty simple. So far, as per the Medical Termination of Pregnancy Act of 1971, unmarried females who were carrying and who were between the 22 to 24 weeks of pregnancy stage would not go for abortion or could not go for abortion. And expressing major concern over these provisions, the Supreme Court has declared that this abortion law, that is Medical Termination of Pregnancy Act of 1971, which prohibits unmarried women from ending pregnancies up to 24 weeks old, is manifestly arbitrary, and it violates one basic fundamental right. What is it? It violates the woman's right to bodily autonomy and dignity, which once again is a part of Article 21 of the Indian Constitution, which is once again related to protection of life and personal liberty. All right, the context is pretty simple. Here we are talking about right to bodily autonomy and integrity. Right to bodily autonomy or and integrity, which is it is completely at left to my discretion about what I should be doing with my particular body, whether I should go for abortion or not, whether I want to keep the child or not. It is completely left to me. So this is called as bodily autonomy, and this right to bodily autonomy and integrity forms a basic part of Article 21 of the Indian Constitution. This has been observed by the Supreme Court of India. Why was it in news? Because a woman who was carrying, who was 24 weeks pregnant, had approached the Supreme Court because she was denied abortion at various places or in various hospitals because of the Medical Termination of Pregnancy Act of 1971, which prohibits unmarried women from going for or opting for abortion who are between 20 to 24 weeks old. All right. The Supreme Court has mentioned that the rules provide for the termination of up to 24-week pregnancies in 7 distinct instances, but it was so far not available to unmarried women in India. And the seven distinct instances include juveniles, those who have physical disabilities, fetal malformations, and rape or sexual assault survivors. Right? The Medical Termination of Pregnancy Act was enacted in the year 1971, and it was amended, or the rules were brought in the year 2003, and it prohibits unmarried women to opt for abortion who are between 20 to 24 weeks old. Alright, so medical termination of pregnancy refers to a medical procedure used to terminate pregnancy with the help of medications. So with this being said by the Supreme Court, now the center has to once again make some amendments to this particular legislation, that is Medical Termination of Pregnancy Act of 1971. Third one is NAFIS for the news. What does it stand for? NAFIS means National Automated Fingerprint Identification System. It is a pan-India system wherein the fingerprint data of all the accused or criminals shall be stored online, and utilizing this, solving the cases become easier henceforth. So NAFIS here stands for National Automated Fingerprint Identification System. NAFIS here stands for, it is related to fingerprint identification. Please note this down. It was recently launched by the Union Home Ministry, and Union Home Minister Amit Shah had launched it. This particular software or identification system has been built by the National Crime Records Bureau, that is NCRB, National Crime Records Bureau. So utilizing this particular software or the platform, the Home Ministry can take the help of fingerprints of criminals who have involved in various criminal activities across India and ensure speedy justice, which once again is a part of Article 21 of the Indian Constitution. So NCRB has developed NAFIS, which the Minister of Home Affairs claims will aid in the speedy and simple disposition of cases with the aid of a centralized fingerprint database. And with this, the state of Madhya Pradesh has become the first state in India to use NAFIS to identify a deceased individual in April of this year, that is 2023. It was launched this year itself, and Madhya Pradesh has become the first state in the entire country to take the help of this particular software. It has been developed by NCRB, that is National Crime Records Bureau. The features include this particular platform or software assigns a unique 10-digit number, just like Aadhaar card. It will be assigning a 10-digit fingerprint number to each person arrested for a crime, and the unique ID shall be used for the person's lifetime and different crimes registered under different FIRs. Right? It is a web-based application functioning as a central information repository by consolidating fingerprint data from all states and union territories. What is the significance of this? By automating the collection of fingerprint data, NAFIS shall help provide the much needed unique identifier for every arrested person in the CCTNS. CCTNS here stands for Crime and Criminal Tracking Network and Systems Database. It will help in the quick and easy disposal of cases with the help of a centralized fingerprint database. Quick revision. NAFIS has been launched by NCRB, that is National Crime Records Bureau, to help the Union Home Ministry. Why? To ensure speedy justice. How? By registering fingerprints of criminals involved in various crimes. That's it. Next is about the delimitation of Jammu and Kashmir. It was a news because in the year 2019, a particular act named Jammu and Kashmir Reorganization Act of 2019 was passed, and according to this, the state was divided into two union territories. One is Jammu and Kashmir Union Territory, the other one was Ladakh Union Territory. So, as per this act, it became a necessity to constitute a delimitation commission to demarcate the areas, from the perspective of assembly elections. So here basically what we need to understand, which are the two constitutional provisions which are related to the delimitation or the exercise of delimitation. They are Article 82 and Article 170 of the Indian Constitution. According to Article 82 of the Indian Constitution, after each census, the Parliament should enact a delimitation act, under which a delimitation commission has to be constituted, consisting of retired Supreme Court Judge, Chief Election Commissioner, and concerning state election commissioners. All right. So the members of the Delimitation Commission shall be retired Supreme Court Judge, Chief Election Commissioner, and concerned state election commissioner. This Delimitation Commission should be and shall be constituted by the President of India. Right. And according to this particular act, that is Jammu and Kashmir Reorganization Act of 2019, a separate delimitation commission was constituted for the Jammu and Kashmir Union Territory, and according to which 7 new seats have been proposed. 7 new seats have been proposed. It is not necessary to remember all these names. Just have a brief overview related to the delimitation commission. And the first delimitation commission after independence was constituted in the year 1952. Right. So after that, as per the census of various decades, in the year 1952, 1962, 72, 2002, delimitation commissions have been constituted. Right. So, however, between 1981 and 1991, the delimitation commissions were not constituted. So all we need to know is 2 articles. One is Article 82 and the other one is Article 170. And recently, this delimitation process was in use in the context of Jammu and Kashmir being reorganized into 2 union territories. One is the Union Territory of Jammu and Kashmir, and the other one is Union Territory of Ladakh. And the delimitation commission shall be appointed by the President of India, and the members include a retired Supreme Court judge, the Chief Election Commissioner, and concerned state election commissioners. Next, recently new election commissioners have been appointed. The position of election commissioner has been filled by retired IAS officer Anup Chandra Pandey. He is from the Uttar Pradesh cadre, and who appoints these election commissioners? It is the President of India, Rashtrapati. All right. There was a lot of hue and cry over the vacant positions of election commissioners. The positions were vacant since April 13 due to Sushil Chandra's promotion to Chief Election Commissioner. And what is the Election Commission? Election Commission of India is a constitutional body because it has been established under Article 324 of the Indian Constitution. As a result, we call it as a constitutional organization tasked with what? Tasked with conducting elections in India in accordance with the laws and guidelines outlined in the Constitution of India and the Representation of People's Act of 1955. It was established on January 25th, 1950. It is concerned with conducting elections for state assemblies, parliament, the posts of president as well as vice president. These 4 tasks are assigned to the Election Commission of India. It is a multi-member body, meaning it consists of 3 members. One is Chief Election Commissioner and the other 2 are election commissioners. As a result, we call it as a multi-membered body, and initially it was not a multi-membered body. It only consisted of Chief Election Commissioner. So the age limit is 6 years or 65 years. They can serve for a period of 6 years or they can serve till they are 65 years, whichever is earlier. And the removal is called as impeachment. How they are removed? They are removed through the process of impeachment, and perks are equivalent to provided to that of Supreme Court judges of India. Can they be reappointed to the same position? No, they cannot be reappointed. Alright. So, Election Commission of India is a constitutional body established under Article 324 of the Indian Constitution. It is a multi-membered body consisting of 1 Chief Election Commissioner and 2 election commissioners, and the age limit is 6 years or 65 years, which means they can serve for a term of 6 years or up to the age of 65 years, whichever is earlier. They can be removed only through impeachment, and the perks are equivalent to that of Supreme Court judges of India, and they cannot be reappointed. Alright. So next is national party versus state party status. Why is it in news? Because recently Aam Aadmi Party has been given the status of national party, and the national party status of 3 parties, that is All India, Trinamool Congress, NCP and CPI, were revoked. So as a result, we now have 9 national political parties, and this recognition shall be given only by the Election Commission of India as per the provisions of the Indian Constitution. So once again, Recently, the Aam Aadmi Party was given the status of national party, and the national party status of three other political parties were revoked. That is All India Trinamool Congress, the NCP, and CPI. What is the eligibility to get the national party status or the state party status? See, to get the national party status, a party should get 6% of valid votes in four states or more, in addition to four seats in Lok Sabha from any state or states. Or this is one criteria. Or if it is not able to achieve this, it has another option, that is 2% seats in Lok Sabha and members are elected from three different states. So if a party is able to meet one of these criteria, then that party can be called as a national party. Similarly, if a state party wants to call itself or get the status of a state party, it should meet these either of these criteria. First one is 6% of valid votes in a state, polled valid votes in a state, plus in addition to this, two seats in assembly. Or if the party is not able to achieve this one, it has got another option, that is it should secure 3% of total number of seats or three seats in assembly, whichever is more. If a party is able to achieve this either of one criteria, it will be called as a state political party. So, what is so much interesting about having these perks, that is national party status or state party status? There are associated benefits. One is a registered political party or a recognized political party would be getting exclusive symbols. For example, right now we have the lotus as the state party symbol for the BJP, and hand symbol as the party symbol for the Congress party. So like that, exclusive symbols shall be allotted to the registered or recognized political parties, and the contestants contesting from recognized political parties need only one proposer while filing their nominations. They shall have free access to one electoral roll, and they'll get broadcast facilities for free of cost through Akashwani medium, and they can have up to 40 star campaigners. They might be celebrities or senior leaders or most sort of leaders, popular leaders. Next one is alternative dispute resolution was in news. Why? Because recently, for the first time, Chhattisgarh has instituted Lok Adalat in jails all over the state. Lok Adalats, they are statutory bodies, and the composition includes, it shall consist of one judicial officer and one local member. Lok Adalats are nothing but they are a part of or a significant part of alternative dispute resolution mechanism in the country. An alternative to litigation, alternative dispute resolution is the practice of resolving disputes outside the courtroom, not entering into the courtroom, such as through arbitration, conciliation, mediation, or negotiation. The objective is to end the dispute through negotiation between the parties. All right. So the meaning of Lok Adalat here is people's court. They are based on the Gandhian principles. It was envisaged by the Mahatma Gandhi. All right. So Gujarat was the first state to institute Lok Adalat in the year 1982, and they were given statutory status in the year 1987. So negotiation, mediation, collaborative law, arbitration, conciliation, all are a part of the ADR mechanism, that is alternative dispute resolution mechanism. Next, we have Press and Registration of Book Act of 1867. Why was it in news? An amendment bill to amend this particular act, that is Press and Registration of Book Act 1867, uh, is supposed to be passed. All right. So it was introduced in the Lok Sabha in the year 2022. However, it is still not passed. It is still pending in the Parliament. The bill seeks to amend the original act, which is Press and Registration of Book Act of 1867. Please remember, this act was passed or introduced by the British after the revolt of 1857 to censure or to limit the growth of resentment through various print media. it is a direct outcome linked to the revolt of 1857. Alright. So, new amendments in the bill include the repealing of current rules governing the registration of books and related issues. And this legislation would do away with the current practice of publishers and printers submitting declarations to the district magistrate for verification. And it is also suggested that the press registrar general handle title and registration simultaneously at a central location for publications, including newspapers. So these are the important provisions of the new bill related to press and registration of books in India. Next, Places of Worship Act was in news. So the original act was passed in the year 1991. Recently, the context was the judgment of Supreme Court's five-judge constitution bench in the Ayodhya case, according to the Solicitor General, may not be covered with regard to the legality of the Places of Worship Act of 1991, because there is an exception under this law. When this law was enacted in the year 1991, an exception has been provided, that is, the act would not apply to the contentious Ayodhya site. And due to this exemption, the Ayodhya case trial continued long after even the law's implementation. So, what is the main provision of this law? See, this law seeks to prohibit the conversion of place, any place of worship, not persons, any place of worship, and to provide for the maintenance of the religious character of any place of worship as it existed as on 15th day of August 1947, and for matters connected therewith or incidental thereto, which means the act simply says that although the act was brought in 1991, it had a retrospective effect, which means as of 15th August 1947, the status quo, or those where temples existed should be considered as temples, where masjids existed should be considered as masjids, where churches existed should be considered as churches. All right. Any wrong information or based on any false information, a religious place cannot be converted, maybe based on historic data, or maybe based on the available data, or maybe based on various beliefs. Any place cannot be converted. It should continue to exist as it existed on the 15th day of August 1947. So this is the main provision with respect to the Places of Worship Act of 1991, and the exemption has been provided to the Ayodhya site where the new Ram Mandir is being constructed. Alright. Next, family courts was in news. Why was it in news? Because an amendment bill, that is Family Courts Amendment Bill of 2022, was approved by the Lok Sabha, and it concerns with modification of the Family Courts Act of 1984 in order to establish family courts in Himachal Pradesh and Nagaland. Why is it necessary, or why was it necessary? See, this particular act, that is Family Courts Act, was enacted in the year 1984. However, it did not mention the family courts which existed in the states of Himachal Pradesh and Nagaland. As a result, various petitions were filed in the High Court, and because of this, the Parliament enacted a bill, that is Family Courts Amendment Bill of 2022, which sought to amend the Family Courts Act of 1984 and provide the establishment of family courts in the states of Himachal Pradesh and Nagaland. Remember these two names. Alright, so this will ensure the swift resolution of disputes pertaining to marriage, family affairs, and other connected concerns. As of April 2023, we have around 715 family courts across 26 states in India. And who will head these family courts? Judges who will be heading this family court shall be appointed by the respective or concerned state government. Alright, this can be done with the approval of high courts, concerned high courts. Alright, okay. So this was it for today. I hope today's class has been helpful. Please do